ready to reconvene again, 10:30. Any questions? Any questions that anyone has about how CLE credit is in the back, of course, and et cetera. Okay, all right, so we're pleased to have with us Professor Jules LaBelle, and again, following sort of informal formality, I'm going to ask him to introduce himself, share with us whatever he likes, and then proceed with his interesting topic.
I teach constitutional law here at the law school, and I'm also a litigator who, for the last 30 years, have been involved with the Center for Constitutional Rights and a number of key cases. I'm going to talk about one of those cases today, which is a class action case that I brought on behalf of prisoners in California who were in solitary confinement. But let me start off by just saying the broad topic of my talk is what kind of relationship or participation should a client have between the client and the lawyer and in the lawsuit? How much control or decision-making authority should we give to the client with respect to the process of their lawsuit and with respect to the litigation? And this is an issue that has beguiled lawyers and clients, I think, throughout the course of at least our history. And I would say that, just to start off with, that a basic concept in both American politics and law, in American democracy, is the concept of representation. In politics, the framers of our Constitution eschewed a participatory model, which many of the states had. New England town meetings, the idea that democracy was when people actually participate in the government. Instead, they adopted a representative model where we participate in the government, in theory anyway, by electing representatives who then govern and decide what to do. Benjamin Rush, who was one of the signers of the Declaration of Independence from Pennsylvania, and who was a prominent political activist in this era, said of our system of government, all power is derived from the people, but they possess it only on the days of the election. After this, it is the property of their rulers, namely the representatives we elect. And Madison, in the Federalist Papers, saw that the reason for this is that you want a representative who would have the spirit of disinterestedness, namely somebody who would rise above the passions of the people, the emotions of the people. And Madison said that our government is based on the principle of representation, and he drew a distinction between Greek democracy and the American Republic. The difference, he says, lies in the total exclusion of the people in their collective capacity from any share in the latter, namely in the United States. This wasn't true in the states. I mean, for example, Pennsylvania had a provision in the Pennsylvania Constitution which gave people the right of instruction. If enough people got together and signed a petition saying they wanted their representative to vote a certain way on a bill, the representative was constitutionally bound to do so. Madison and the other framers rejected such amendment to the U.S. Constitution. And in Pennsylvania, and in many of the other states, the theory was you want people to participate as much as possible, and to encourage participation in the legislative process. So, for example, in the early Pennsylvania Constitution, no bill could be enacted in just one legislative sitting. It had to go through a process where it was enacted, then publicized in the newspapers, and there had to be meetings about it, and then you'd come back the second time with that popular input and enact the legislation. I start off with this simply because I think lawyers in the United States are in a parallel situation, in a sense, to representatives. The key aspect of the American legal system is that you, at least for major cases, you're not supposed to go into court on your own and argue the case yourself. You have a lawyer who's your representative. And so the question is, for legal purposes, but purposes of our legal system, what should be the relationship between the representative and the constituents, in this case, the client? And I think there are many parallels between the American conception of that relationship and the American conception of the representativeness of our government. Not totally parallel, obviously, but first of all, a lawyer is seen in Rule 1.2b of the Model Rules of Professional Conduct as a lawyer's representative of a client does not constitute an endorsement of the client's political, economic, social, or moral views of their activities. And so the theory, I think, is one a little bit similar to Madison's theory of disinterestedness, that a lawyer who has himself or herself as a client has a fool for a lawyer. The idea is that a lawyer gets away from the emotional, passionate conundrums of the client and could represent the client from a broader, rational spirit, I think what Madison would call in the political realm disinterestedness. Under this traditional view, the lawyer has quite a bit of autonomy in deciding how the litigation should go. It's a pretty hierarchical relationship. The client obviously has the final authority in that the client could fire the lawyer or decide that the client, in settling the case, the client could decide they want to settle the case. Some basic decisions can be made, but it's, I think, generally a hierarchical model in which it's a lawyer-centric model in which it's premised on the perspective that the client essentially delegates to the lawyer the responsibility for carrying out the litigation. You see some sort of quips or common conceptions among lawyers who follow this kind of traditional conception. There's many, many quotes. The practice of law would be wonderful if it weren't for clients. The lawyers are experts who can and should determine in a detached and rational manner, with some minimal client input, the best solution to a particular problem. The clients lack the sophistication to be engaged in this kind of decision-making. Clients are too emotionally wrapped up in their problems. The clients do not have adequate expertise to think of the potential long-term questions that come up in the course of the litigation. And the lawyer's job is to explain to the client how the law will, or to operate on how the law acts. And the client really doesn't know that. So that, I think, is the traditional model. That model came under attack in the 50s and 60s, first by the development of cause lawyering, public interest lawyering. The NAACP and Brown versus Board of Education and the whole civil rights campaign questioned the notion that lawyers should be detached from their clients in terms of not reflecting the moral, political, or social views of their clients. That the lawyer should just be a hired gun, take whoever comes in. And they believed, of course, that the lawyer, the NAACP, the Inc. Fund, the Legal Defense Fund, in its different manifestations, should reflect that the client and the lawyer should have the same political and social view. Namely, the lawyer was not just doing this because they wanted to take this case, but because they believed in the cause. And the same thing is true for the ACLU, the Center for Constitutional Rights, many other public interest litigators. Now, that raises its own set of problems. Who is the client? Is the client the cause, or is the client the individual? And there could be many tensions surrounding that. you know, there was a lot of tensions with Thurgood Marshall, because Thurgood Marshall, like the traditional law perspective, wanted to control the whole movement. He said, I don't like people engaging in civil disobedience. This harms our efforts in the court. The movement on the ground should just sort of wait for the lawyers to develop the cases, and we're going to win this thing. You're sort of an adjunct. I think, to me, the most amusing thing he said was about the Montgomery bus boycott. He said, all that walking was for nothing. They might as well have waited for the court decision, which said, you know, this segregation of the buses was unconstitutional. So why did you engage in all this tumult? Derek Bell, our own graduate, said that there was he wrote a famous article on, I think it was entitled, Serving Two Masters, Integration Ideas and Client Interests in School Desegregation. Namely, Marshall and the NAACP were continually pushing their goal was school desegregation. And as the campaign went further and further, many black families began to say, well, is this really getting us quality education for our children? We want quality education, that's our goal. Your goal is desegregation. And Bell wrote a whole article about whether this whole cause lawyering model, where the lawyer basically controls the litigation and the lawyer's goals are paramount, are they really in sync with the client's goals, and could there be conflicts between them? Another example of this is the lawyer for Mr. Kelly in Goldberg versus Kelly, which established the right of welfare recipients to a due process and to a hearing, said John Kelly was not a real person to me. He was an occasion. Namely, the lawyer went out, found the plaintiff, or figured out a case where there was a good plaintiff, and then the plaintiff's almost irrelevant. The key is developing the principle. And there was a lot of tension even in the NAACP. The NAACP's head at one point, Roy Wilkins, put it, people are saying the Inc. Fund may win a great principle, but what about us? So again, the whole cause lawyering, public interest lawyering raised the same problem, but even in a more extreme way, because the lawyer was seen as more interested in the cause. Mel Wolfe once famously said, my client is the Bill of Rights. Well, if your client's Bill of Rights, what about these other people who you may like or dislike or feel repulsed by, but you're representing them because they have cases which raise Bill of Rights questions. For those of you who saw On the Basis of Sex, the film about Ruth Bader Ginsburg, there's a prominent scene which raises this question. In her 10th Circuit appeal on a particular case, Mel Wolfe, the head of the legal director of the ACLU at that point, says to her, you got to settle this case because we have Reed versus Reed coming up in the Supreme Court, and that'll be a better case. We don't want the 10th Circuit mucking this up. And she says, well, but I want to litigate this, and Mr. Moritz, the client, has this particular interest. He says, we want you to settle it. She goes to the client says no way, and of course they can't settle it for that reason. I did a couple hours worth of research to see if that was real. I think there's a piece of it's probably exaggerated for Hollywood, but it reflects the real tension, and I think there was some reality to that. I know that the government wanted to settle. And another problem, which may have been a problem which they didn't explore in the movie, is that Ginsburg might not have wanted to settle because she wanted to develop a great principle, and the client's interest might have been in settling. In that case, it probably wasn't because it was a few $100s that was at issue. But that's another kind of tension that comes to the fore. In any event, out of the problems that this cause lawyering engendered, a new movement grew up and a new conception of lawyer-client relationships developed through both clinical legal education and legal services, which was called client-centered. And as opposed to the cause-centered, or as opposed to the lawyer-centered view of traditional law and of cause lawyers, the client-centered said, we've got to change the relationship between lawyers and clients here. The lawyers can't be just seen as this hierarchical figure where you propound theories to the client and then you take the case and the client has very little to do with it. The lawyer should listen to the clients, should dialogue with the clients, should be concerned about the client's broader problems, not just their legal problems, should work collaboratively with the clients to try to develop a solution. This gave rise, this went hand in hand with ADR, with mediation, that maybe the best solution is not a particularly legal solution or not something you can win in court, and that can only be done in a collaborative, client-centered way in talking and working with clients, and not in a hierarchical, we know the law, this is what we're going to do, you're just relegated to the sidelines. The client-centered view was that a wider range of decisions ought to be made, at least in consultation with the clients, or perhaps even primarily by the clients. Now this raises its own questions. It raises questions of efficiency. I once represented in practice the estate of Albert Einstein, and the trustee of the estate was Einstein's best friend, and he was 90 by the time this suit came by. But he wanted to be directly involved in the litigation to the point that he wanted to read every brief and go over it. And it was quite annoying. So this client-centered approach we didn't think was very efficient. That's number one. Number two, there are times when it raises even constitutional problems. So for example, in the criminal defense context, the client has, the Supreme Court has held, the client holds the basic decision-making about whether to request a jury trial, whether to whether to plead guilty or plea bargain, whether to be called as a witness. The client can say, I don't want to be called as a witness. Those 3 or 4 decisions, but every other decision is for the lawyer to make. Now, what if a client says, this happens a lot, I want this person to be called as a witness. I think they'll be a great witness. And the lawyer says, but wait a second, I've interviewed this witness. Not only will this witness not be a great witness, but this witness is going to harm your case significantly. Who controls that decision? Now, if the client controls, can the client then, after they get convicted, turn around and sue the lawyer, or can some other lawyer, can the client get some other lawyer and say, this was ineffective assistance of counsel because you put on a witness who was terrible and sank the case for us, even though that was the witness that I wanted. So you shouldn't have listened to me because as my legal representative, you should have taken a broader view. And that's happened. This isn't a hypothetical situation. It's happened, and so the question is, how much decision-making authority should we give clients, even under the client-centered model, and is the giving too much decision-making authority to the clients inconsistent with certain constitutional obligations of the lawyer, particularly in the criminal defense context, to represent their client effectively? Or is the only alternative for the lawyer, if they really feel this is ineffective, to resign, which is a draconian decision. So that, I think, if we talk to clinicians here, Martha's here, I bet you that in clinics at Pitt, as well as clinics all around the country, there's case books on the client-centered method of litigation or representation. And it was a whole reaction to both this traditional view of lawyering, as well as the broad cause lawyering field. And I think legal services too. There have been a number of case books and very prominent scholarly works on a client-centered model. In the last 10 or 15 years, there's developed, I'd say, off of the client-centered model, yet a different perspective on the relationship between the lawyer and the client. And that is, it's been called either rebellious lawyering in one famous book by Professor Lopez, or community lawyering, or movement lawyering. I'm going to call this whole trend participatory lawyering and participatory litigation. It's the view that it's not simply enough to listen to clients or to work with clients, but that clients have to be enabled to actually participate in the litigation that they're involved with. For example, there's now the founder of this group won a MacArthur Genius Award. There's a group that's started in California, but has developed around the country, in which communities, people who have relatives that are in the criminal justice process, meet together and go over their case and try to come up with community community ideas on how to defend the person. They also then meet with the public defender, who at first looked at this antagonistically, but are now seeing that this is a great asset to them. And the theory is to get actually the community to participate in the defense in some concrete way. I met about a number of years ago with a group in Boston, which was working on mortgage, foreclosures and tenants' rights. And what they do is they work with Harvard law students, and now I think lawyers, where every week there's a meeting of people who are going to be evicted or have gotten evicted notices, and they meet with lawyers, but the lawyer's job is to help them and prepare them to make their own defense in court. And that the idea is that as more and more people are successful, or they get help through this way, they'll come back and the meetings will grow and bigger and bigger, and there'll be more people to help people as to participate in their own going to court. My own experience is with prisoners. As I said, I brought with the Center for Constitutional Rights an action representing about 1,500 prisoners in solitary confinement in California. These were people who were confined 23 hours a day to a small cell, no windows, just themselves. And they were confined this way in some cases for 10, 20 years. I would think it would drive anyone crazy, but they hadn't been driven crazy, but they were objecting and trying to politically change this. They got no phone calls, they had no contact visits, they for years never touched in any meaningful way another human being. They had no educational programs, religious programs. 1 hour a day, they went out to it's hard to call it a yard. It was a facility that was 2 or 3 times as big as their own cell, with 15-foot high walls and a grate over it, where they could exercise. And there was nobody else was there. There was no exercise equipment, but that was their 1 hour a day out of their cell. They never saw the sun. They never saw other people. They never saw trees, cars, anything. So in this context, we saw just what got us involved is that these people went on hunger strike in 2011. Thousands of prisoners went on hunger strike. And it got national and international attention, and it forced the prison officials to at least consider reforming the situation. And then they came to us and we brought a class action lawsuit on it. So in this context, the idea of participatory litigation was these people had no control over their lives at all. And I think the broad conception of participatory litigation is that it's attempting not only to win substantive goals, but to democratize both the legal system and the institutions that are controlling people's lives, or that people interface with. These folks had almost no control of their life at all. They were in prison, number one, leading to very little control. But even within this regime of solitary confinement was dehumanizing, deprived them of the general of human dignity, and gave them almost no control of their life, which is why all the social scientists and psychiatrists who interview these people say, even if they haven't gone crazy, they're under tremendous stress, because one key factor in stress is having some control over your life. So we saw the litigation as not simply a means to win a substantive goal, namely getting them out of solitary, which was our main goal in the litigation, but also that the process of the litigation itself had to be in some way restoring of human dignity, restoring of humanity, and the way to do that was for them to participate in their own liberation from this system. And that led to a couple of things. One is that during the course of the litigation, yet another hunger strike broke out, this time involving 30,000 prisoners in California. And for about 100 of them, lasting to almost to the point of their health being seriously compromised. The question was what the lawyers' view and relationship to this hunger strike was going to be. I mean, we didn't think it helped our case in court, because judges aren't, particularly if our judge saw this as a way of affecting the judicial decision, we thought she would take umbrage at that. Yet we supported the hunger strike, and we saw that a key piece to this idea of participatory litigation was combining social activism with the litigation. That people had to feel that they had that their own activity could change the situation, and not just relying on the lawyers to do that. And so, as I said, one way we tried to do that is encouraging and furthering their own activity, their own political activity. Another way we saw that is highlighting their own story. This was incredibly difficult because journalists couldn't go into the prison, couldn't interview people. We weren't allowed to bring any tape recorders into the prison. Cameras couldn't be brought into the prison. And we felt that our clients had to be humanized in some way through their own, not through me telling the story, but through their own telling of the story. So how to do that? Well, we hit upon a mechanism which is the state deposed all of their 10 named plaintiffs, and we demanded that the depositions be videotaped. Once they were videotaped, and then they became open to the public, and we did a video of their snippets of their depositions. The New York Times did a video of snippets of their depositions, put it on the New York Times website, and we felt this was one way to have their voices actually be heard, as opposed to the lawyers just speaking for them. Second thing, which I'm not sure, I'm not sure how effectively we did this, but we tried to, with respect to the tension between the clients and the lawyers making decision, we erred on the side, if we erred, on the side of the clients giving the clients much more decision-making and participation in the substance of the lawsuit. So for example, when we were almost done drafting our complaint, I got a letter from one of the clients saying, have you considered this whole new approach? And at first I said, well, I know more about this than I had already litigated in this area. What is this? This is not going to work. But then I said, well, maybe this person has a theme, some idea. That's good. So I got my research assistant researching it. And it turned out that this prisoner who had become sort of a quasi-lawyer while in prison had a very good idea. And we wound up putting that as one cause of action in the complaint, and we eventually won on it. And we had a series of things like that, where clients would want to do things, would want to make decisions, where we weren't quite sure that that was the right decision. But in general, we came down on the side of this was in terms of litigation strategy, not in terms of settling the case or whether they were going to be witness. This was in terms of whether we should file a supplemental complaint. We understood why they wanted to, but we thought it would delay the trial for a couple of years, and delay was bad in this situation. We argued with them. They said, no, this is really what we want. And we said, okay, we'll do it. And it wound up being a key aspect which finally forced the state to settle the case, filing the supplemental complaint. And it didn't delay the trial. So what we tried to do was work around our clients' decision-making and use our knowledge of the law, as long as their decision-making wasn't whack. I mean, we wouldn't do something which was totally inappropriate. But as long as their decision-making was reasonable, we tried to encourage them making decisions on this. And then third, and another aspect of this was the whole settlement process. Eventually, the state came to us, and after this litigation has been going on for 7 years, and there's no sign of it ending, even though 3 years ago we settled the case. The state finally came to us and said, we're interested in a settlement. And they wanted to talk to the lawyers. And we said, no, you can't just talk to the lawyers. We have to meet with all of our clients. Now, all of our clients were in solitary. The state said, this is not possible. They're too dangerous. You can't have a meeting with them like we're meeting here. And we said, well, then we can't settle it without. They said, well, you can take whatever we come up with and talk to them individually and see if they individually agree or disagree. He said, that's not the process we foresee. We foresee that they are going to come up with their settlement proposal through a mutual meeting. And the judge eventually strongly recommended to them that they do this. And so they created a meeting in the middle of in the prison. All these, the 10 guys were all in like cages. We had to wear Green Beret flak jackets to come into this, because even though they were in the cages, they somehow felt they were so dangerous they might shake the cage, like Hannibal Lecter, shake the cages and get out somehow and kill us. But we had 2 3-hour meetings where the clients actually came up with their settlement proposal. A settlement proposal which in some respects, some critical respects, I never would have thought of, even though I knew the law backwards and forwards. And because they knew the history, the 30-year history of the prison system from their experience, and they came up with proposals, which we then took to the state. We met with the state, but we said on a couple of key meetings, we said we need the prisoners on the phone with us. When I said met with the state, I was in Pittsburgh and the state's in California, so it was mostly phone conversations. We then, every 2 weeks, we'd have another draft of the proposals. And by this time, the clients were spread around the different prisons around California, so we couldn't meet with them. but we arranged conference calls with all of our clients to go over the settlement point by point, with them making negotiating recommendations. And after 3-4 months of this, we finally had two phone conversations where they decided on whether to agree to this settlement. And there was strong debate on whether to agree, but they finally, almost unanimously, agreed. So that was the settlement process. Then the last piece of it, which I'll end on, is we also thought that the settlement had to include not just the substantive change that these people would get out of solitary, which is what happened. In fact, not only did our clients get out of solitary, but they expanded our suit from one major prison to all the prisons in California, and everybody got out of solitary. This indeterminate solitary, there's still solitary in California, but there's no solitary of the kind that was experienced, which was indeterminate just for being a dangerous person or a gang member or something like that. Now you have to, pursuant to our settlement, they have to have a disciplinary hearing, find somebody guilty of a specific crime or misconduct, and then sentence them to some determinate period of time in solitary. And that was, that was a huge advancement, a huge reform, which the clients were thrilled about. But in addition to that, we said that we got 2 years of monitoring, and we said we don't want the lawyers to simply be the monitors. We want, obviously we have to play the major role, but we want our clients to be actively engaged in the monitoring and implementation of this. So we want you to have to meet with the client representatives every 6 months. The prison officials would have to meet with them, not with us, to discuss the implementation of this settlement. We want every 6 months for us to be able to meet with all our clients to discuss how the settlement's being implemented. We want, if there's critical reports, we want you to meet with the clients so that they can give input. None of this was decision-making, but input, participation in the implementation of the whole thing. And the interesting thing was, even after the state said, we will settle this, and we will agree on the substantive goals, they absolutely refused to do any of these participatory things. Because doing any of those things would elevate the clients who were murderers or, bad people who had committed misconduct, had committed crimes, to the same level as the prison officials. And that was our goal. Our goal was that human dignity, democracy requires that they at least see these prisoners as being able to participate in how things were run, in some of these decisions. Even if they were behind bars, even if they couldn't be let out into society, we wanted to both restore their human dignity and give them some democratic participation. And the prison officials said, we'll settle on everything else, we'll end solitary as we know it, but we are not going to let them meet with us, because that's going beyond the pale. And so we said, well, we can't settle then. And we finally had to arbitrate that before the judge, and he said, well, give them half of, not every 3 months, every 6 months, not every 6 months, every year for something out, whatever it was, he cut a compromise, but basically it allowed those participatory ingredients in the settlement. So to conclude, I would just say, I think our task as lawyers ought not to simply to be to present effective arguments for our clients in court, but also to allow our clients to feel that the legal system is not just an alien oppressive system to them, but that they really have some role, some control, some participation in the cases that govern their lives. So I'd end with that, and hopefully there's some questions. Rhonda?
I had 2 questions. The first is, in the last maybe half of your talk, you incorporating this participatory model, but early on in your talk, you really spoke critically of the lawyer, of the person representing Einstein's estate who wanted to play a role. So it seemed like, so I'm just curious about that sort of frustration with one client who wanted to play a role and your celebration of the prisoner's interest in playing a role. So that's one question. The second question is, in the class context, typically the class has to be so large that it would be impossible to join them individually. You talked about thousands of prisoners, but when you had your meeting, you had only, it sounded like 10.
The 10 named plaintiffs, right?
Okay, so I'm curious about, and often with classes, you can have people that are geographically far apart where it would be impossible to have a meeting. So I'm just wondering how this participatory model works for the absent class members, and especially when they're geographically dispersed.
Yeah. On the first question, I think the key word you used was celebratory, which I think was over-optimistic. I wanted to present this model, and I wasn't presenting the frustrations with it. The frustrations are that I have a client that's a convicted murderer, and he's a very smart guy, and he says, I want to write this directly to the judge. And I say, I don't think it's going to be that helpful. But he says, I want to do that. And there's a tension, there's a frustration. And I think Karen, my wife who's here, Karen, could tell you how frustrating at times this has been. I gave you a rosy picture, and I think your question reflects that it's not all that rosy. You know, that there are real tensions in this. I gave you a rosy picture because I wanted to push against the traditional view, which has a whole different theme, and present the positive aspects of this. But there are negative aspects of it too. Inefficiency, it takes a lot more time. For example, just so and that's happened throughout this litigation. That it's both more time consuming to do it this way. And it raises some tensions often. But I think it's worth it in the long haul to create a different model. Second thing is, I don't think in American democracy or in American law we can get away from the representative model. So in the class context, we had to have representatives, namely our named plaintiffs. One of the early decisions we made, which turned out to be troubling in some respects, is often in these class contexts, you pick your 2 or 3 ideal plaintiffs, and that's it. We picked 10, which was a fairly large number for these kind of lawsuits. And we picked 10 because we wanted to have a diverse group of representatives. We didn't just want to have representatives who had the great, the case that they'd been thrown into solitary for nothing. We didn't want to have, in the political movement, we had African Americans, Hispanics from Northern California, Hispanics from Southern California, whites, and all these people had been part of groups like the Aryan Brotherhood, or the Black Nationalists, or the Mexican Mafia, whose names sort of suggested that there were going to be problems. But we decided to try to integrate this so we had absent class members, but we had a pretty broad representative model, and we thought it was more representative than just us, or just 1 or 2 people being the representatives. What we tried to do is not just consult with our representatives, but to consult with a wider group of people. They were, at the beginning, they weren't geographically dispersed because they were all in this one prison. The one prison happened to be in an incredibly isolated part of California, right between California and Oregon, right near the Oregon border. and it took 7 hours to get there just from San Francisco. And it was placed there intentionally, so that these people would be very, very isolated, and their families, particularly since most of them were from LA, it was very, very hard to visit. But we had the advantage that we could go visit them all in one fell swoop. I mean, just a few days. But I think that's a problem, and I think that there are class members who resent the representatives and who say, you know, now of course when we settled, we had to get, you know, there was broad comment, which was almost all affirmative, except there was one, after we settled, there were about 20 class members who objected to one provision. And we objected to it also then. And the judge said, you're right, this is an objectionable provision, but she couldn't send us back to the negotiating table. We've been struggling about that provision for a year or two with some not great resolution. Kevin.
Jules, first a comment. I've been going to CLE classes for 30 years, and this is the most moving that I've encountered, so thank you for that.
Moving and rosy.
Well, I did want to press on the rosiness part of it, because you adopted a terminology of participatory model in preference over some more extravagant terms that have been used. I forget exactly what it was, but rebellious.
Rebellious,
Yeah.
movement lawyer, and community.
And you have your reasons for calling it participatory rather than something else. And it made me wonder about other examples of it. So you have described this situation where it seems very apt to have some kind of a participatory activity of the clients, even to the point of hunger strikes. But what are some other examples? I'm just trying to get a sense of whether I would regard those as apt for
Right.
participatory.
Well, as I said, one that's now getting a lot of traction is this participatory defense in the criminal defense context. And let me just read to you from what they do, because I think it's pretty interesting. We started holding this is from, there's a group that started in San Jose, California, and now is spread around the country. It's spread to the Bronx, and it's again based on this participatory model. But here's what they do. We started holding weekly meetings for families whose loved one faces charges. Families would come, share the status of the case, and then the group would come up collectively with tangible ways family and community support could impact the outcome of their case. Every week, families would engage in a range of activities to help their loved ones, such as dissecting police reports, securing investigatory material, producing social biography packets and videos that could be used for sentence or charge reduction, and having a presence in the courtroom so that prosecutors, juries, and judges knew their actions were being watched and held to account. We never called our meetings legal clinics or used the word client, because we wanted to make clear that this participatory defense model was not about the person receiving a better service. It was about becoming the agent of change themselves. And then it goes on from there. So I think that's one example. I think the same thing is happening in housing eviction. And in both of those areas, the lawyers are overworked. The lawyers could use help. There are either very few lawyers, or in the public defender situation, the lawyers are tremendously overburdened. So I think this sort of is an aid to that as a concrete matter. But it also says that it can have an effect on the courtroom. Now, one thing I'd like to mention to undermine the rosy picture that I gave, what I considered one of the key innovations of this settlement, which was that the prisoners would have to meet with the prison officials, has not turned out all that well. The prisoners have met with the prison officials, and the prison officials say, we have to meet, but we're not going to say anything. You know, we're not going to engage in a real dialogue. We're just going to meet with you, because that's what's required. And we've had to go to the judge a couple times on it, and the judge says to them, well, why don't you have a dialogue with them, but I'm not going to order you to do that. And they haven't done that. So you can drag the horse to water, sort of, but you can't make them drink. You know, so it hasn't really worked out. But I think symbolically, the idea that this is what the settlement wanted was maybe a step in the right direction. But anyway, I hope that answers your question a little bit.
So I'm remembering one of our library patrons who was self-taught in legal research and legal procedure, a lot like the people who have time when they're imprisoned to be able to use library resources. And he went to court at least one time, I remember. He had legal representation, but he didn't feel that his lawyer was prepared. And so he went and was able to file for a continuance without the lawyer being involved in filing for that continuance at all. And I thought there must be some procedural reason that I didn't know about, that a client could act without counsel at where they have representation. And I wondered if that's what you're advocating for, or are you thinking more along the lines of just training lawyers to have better interpersonal skills and to see the relationship more fully?
Yeah, I'd say both. I'd say a key thing, and that's the client-centered model of clinics, is that lawyers should have better interpersonal skills. They should listen to their clients. They should, you know, some of the literature describes lawyer-clients meetings where the lawyer comes in with a series of questions designed to elicit what the legal issues are, which is what we learn in law school. And the client-centered model says you should be more open-ended. You should allow the clients to tell you what they really think is important, as opposed to what you want to get out. So there's and I think that's the client-centered model. But I want to go beyond that, is my point, to somehow trying to create ways for clients to have either real decision-making or more participation itself in the litigation or in the eventual implementation of whatever decree occurs. And that's a more challenging, I didn't tell you the other part of the Einstein story, which is that when we arbitrated, it was a big arbitration with Princeton University Press. And this client, when he was on the witness stand, said, I now instruct my lawyer to introduce the following document. And I was a young associate, so I had to scramble around for the document. And finally, the lawyer, who was a very well-known, very experienced, had argued many times the Supreme Court, said, Mr. Nathan, the way this works is I will ask you, and then I'll introduce the document. You know, but it was just so when you get something like that, it's not that helpful. And I could, as I said, in my case, I could argue that some of the times when this participation really had worked, I was aggravated by it because I had thought I created a great legal argument, and here there was somebody mucking it up a little bit. But I think on balance, and that's the tensions. When I'm trying to write a law review article on this, when I write it up, I think the key aspect will be the tensions in this model. But I think overall, the notion of both in our American government, democratic governments, and in law, of moving away from the representative knows everything or does everything, to not only just more of a listening, like town hall meetings, but where the client actually gets some real participation, I think could be a major innovation in how we litigate in our society, or how we represent people. Yeah.
I was wondering, it seems kind of interesting that in that there are physical safety and security concerns to which some of the prison guards would be interested in terms of that settlement. would see that some of the things that I've read about this intersection of mental health and this need for solitary, where people just can't interact with other human beings. They're a danger to themselves and others in terms of the medical profession and the psychiatrists and the psychologists. Did you see any way in which those sort of uninvolved, not that they weren't represented by the state, but certainly they would have interests that might be perhaps different than coming from a different place? Did they get sort of sucked into that, or did their input have an impact on how this sort of worked itself out in terms of the settlement?
That's a great question. And let me just say, let's talk about the prison guards first. I think the prison guards are a critical ingredient to this. And we didn't involve their participation. I mean, they actually participated by filing intervention seeking to negate the settlement, seeking to turn. And what I wanted to do was bring the prison guards together with the plaintiffs' lawyers, with the other stakeholders, as they say, and involve them. I wasn't allowed to do it because they're employees of the state, and the prison officials, I decided I better go to them before I just did this on my own. And the prison officials said, we don't want you to do that. We have enough problems with negotiating with the guards without getting you in the mix. And but I think to really reach some kind of settlement or reform, what you would need to do is involve those other groups. Doctors, prison guards, and the prison guards generally are hostile to reform because they say, this is a very dangerous situation. We don't want to let these dangerous people out of solitary. But more and more there are prison guards who say that the way we're forced to operate is dehumanizing to ourselves too, and that another system might be helpful in making our job less stressful, even if it had some more potential of danger. But anyway, I think you're absolutely right, and that's what I would have liked to have done. I can't figure out a way around the ethical rules. You had one last question?
Just from a practical standpoint, if these prisoners are in solitary confinement, they only get an hour, how did they all figure out they should have a hunger strike?
That's also a great question. It's more than a minute or two, but let me just say, what I am always astounded by is in this context, is the adaptability of people to incredibly bad conditions and the ingenuity of how to figure out. So one way they did it was by passing notes. You get like a little string and you take it under, there's like this much under the door. You get that out, you jiggle it around. If you have an hour and nobody's looking, which tends to happen, you can jiggle it around so that it gets to the next door person. And then they can do the same thing. It's called fishing in prison. So that's one way. The other thing is when they went to the rec thing, there was a drain, and they could yell into the drain, and the person next to them recreating in the next room could hear. It was a pretty dehumanizing way of communication, but they had time on their hands. Thank you.
Thank you.